Next up, we've got Jon Tweedale, who is coming to talk about asymmetrical dispute resolution clauses, which sounds very technical. Jon is in our international arbitration department, and as well as doing corporate litigation, and I'm going to hand over.
Thank you, Clarissa. As Clarissa says, I'm going to talk about asymmetric dispute resolution clauses, or more specifically, what are they, do they work, and why do we care? The potential pitfalls of these clauses has been highlighted by a number of cases over the last 12 months or so. But there was another judgment handed down by the Commercial Court at the end of May, which has brought their use back into focus. But first of all, what are asymmetric dispute resolution clauses? What are we talking about? Well, typically what we're talking about is our dispute resolution clauses or jurisdiction clauses, which give one party a greater choice in the choice of jurisdiction than the other. And I've put a couple of examples upon the slide there. You might have a situation where party A and party agree that any disputes will be submitted to the exclusive jurisdiction of the English courts, save that party B has an option to refer any dispute to arbitration. You might have an arbitration, for example, seated in Paris. Another example you sometimes see, party A and party B agree that the English courts will have exclusive jurisdiction to determine any dispute, save that party B, at its discretion, may elect to commence proceedings in any court of competent jurisdiction. So why use them? Well, they're used because they keep options open. The most advantageous forum for determining a dispute often varies depending upon the nature of the dispute, but you won't know what the nature of the dispute is until it's arisen. So asymmetric clauses aim to give one party options, keeps its options open, and it can have its cake and eat it. If perhaps give you a couple of examples of that, you might have a contract and the nature of the dispute arises is that the party on the other side is breaching its obligations of confidentiality and infringing your intellectual property rights. Now in that scenario, probably what we want to do is to rush down to the local courts of the jurisdiction where these breaches are taking place to get an urgent injunction to stop that happening. You don't necessarily want to rush off and start in relative terms, start an arbitration in Paris and not get any relief for several months and then have to go and enforce it in a court anyway. Another example, however, if the dispute arises and effectively what you've got is a debt claim, then you might be, and the assets of the other party are all located in a jurisdiction, maybe in an African jurisdiction, where they don't generally recognise court judgments, but they will enforce arbitration awards, then in that scenario, really what you're wanting to do is start an arbitration. But because these types of clauses are asymmetrical and they give only one party an option, they give them a tactical advantage. Invariably, they tend to arise where one party has greater negotiation leverage. And perhaps the best example of that is the banks. They tend to have the greater leverage. If you want the money, then you have to agree to my terms. So much for the theory. But do they work? In England, yes. The case I mentioned earlier, there was a case handed down at the end of May by the Commercial Court, Mauritius Commercial Bank and Hestia Holdings. There, the Commercial Court, Mr. Justice Popwell, affirmed that under English law, asymmetric dispute resolution clauses work. But hairs were set running last year when there were two cases. First of all, there was a case in Russia Telephone Company and Sony Ericsson, where the ruling presidium of the Higher Arbitrage Court of Russia found that an asymmetric clause was void because it was asymmetric. And then in September, the French Supreme Court handed down a decision, the Rothschild's case, in which it also found that an asymmetric clause was void, which set hairs running because a large number of contracts, in particular financial instruments, featured asymmetric dispute resolution clauses. I think it's worth looking at the rationale for the rejection of the clauses in those two cases. In the Russian case, Sony Ericsson, I think it was a Russian subsidiary, entered into a distribution agreement with the Russian telephone company to supply mobile phones. The contract contained a dispute resolution clause that basically provided that both parties agreed to arbitration under the ICC rules in an arbitration seated in London. Both parties agreed that alternatively that would not prevent them rushing down to courts to protect their IP rights. But thirdly, Sony Ericsson and Sony Ericsson alone had the option to take action in any court having jurisdiction to recover a debt for products supplied. What happened was the Russian telephone company started proceedings in Russia, bringing a claim that the telephones supplied weren't of satisfactory quality and should be replaced with phones which were of satisfactory quality. The point was taken by Sony Ericsson that breached the arbitration agreement, but held by the Russian court that the option granted to Sony Ericsson represented a breach of a fundamental principle of civil law, that there should be equal treatment of the parties. And there was also a breach of the fundamental procedural principle that the parties should have an equal opportunity to defend their rights and lawful interests. So held, the Russian telephone company could pursue claims in the Russian courts, notwithstanding that that was a apparent breach of the arbitration clause. In the French case, a French national pursued claims against Rothschilds, it was a Luxembourg bank and a French company. In that case, the dispute resolution clause provided that both parties agreed to the exclusive jurisdiction of the courts of Luxembourg, but that the bank reserved the exclusive right to start proceedings in the client's place of domicile or in front of any other competent court. What happened in that case was the French national commenced proceedings in France, held by, first of all, by the Court of Appeal and then subsequently by the French Supreme Court. The positive character of the clause rendered it void. Now, this notion of a positive clause, I think, is a French concept. My understanding of it essentially is that it relates to clauses where the existence of the obligation, its binding nature, is at the will of the parties whose obligation it is. So, applying that to that particular case, effectively, what the court was saying is, if the bank can decide that it is only obliged to sue in Luxembourg if it wants to sue in Luxembourg, but it doesn't have to, effectively the position is in substance that there's no obligation on the bank at all, and therefore the clause falls apart. But the court also found, the Supreme Court also commented, that because of its positive character, it was contrary to the object and purpose of the choice of jurisdiction clause contemplated under Article 23 of the Brussels regulation. In other words, the purpose of Article 23, that's the clause of the Brussels regulation, which is designed to uphold and give the parties the choice to choose which court should have jurisdiction. And it's important for that purpose is that choice is certain. But if you have a clause where it's open more or less to the wide discretion of one of the parties, you lose that certainty. So held that the dispute resolution clause in that case was also void because of its asymmetric nature. And the French national was allowed to continue to sue in France. Do we care? Well, I think we do, because as in the two decisions I've talked about, the probable consequence of the finding that they're void is that the entire dispute resolution clause is treated as void. In both of those cases, the consequence wasn't that the court found that the extra option, the offending part, was void. What the court ruled was that the entire clause went. And what that means is that you will lose the tactical advantages you gain by choosing your choice of jurisdiction in the first place. And the consequence of that will vary from case to case. But in certain cases, or worst case scenario, that could result in a contract being pretty much unenforceable. For example, take a situation where you have a dispute resolution clause which includes an arbitration clause. And the reason you've included an arbitration clause is because the party on the other side has all of its assets in a state which doesn't typically recognise the judgments of foreign courts, but is party to the New York Convention and will enforce arbitration awards. So you've included an arbitration agreement because you want to be able to enforce in the local courts of the counterparty, and you're not happy to go through the courts of the local local courts to determine the dispute itself, because you understand the local courts are either corrupt or unsophisticated, or there's enormous amounts of delay. So what you want is you want an arbitration, maybe seated in London or Paris, and then you want to go over and enforce in the local courts. Well, if the whole dispute resolution clause falls away, you lose that opportunity to arbitrate. It's gone. You're left with going through an unsatisfactory system. It may render the whole contract, in practical terms, unenforceable. And you'll lose many of the other tactical advantages you might have by having a carefully crafted jurisdiction clause. And there's also an increased risk of parallel proceedings, at least where both of the parties aren't in the EU, for example, and there aren't any conventions providing for which court should have jurisdiction in the absence of a clear jurisdiction agreement. So what's the solution? Well, an obvious solution is don't use asymmetric dispute resolution clauses unless you're confident that they'll be enforced. What's the position, though, if you've already got a contract that's already been executed and it already contains an asymmetric dispute resolution clause, and because of the jurisdictions involved, it could give rise to issues because you may have to enforce in France, for example. Well, in practical terms, all you can really do is try to seek out opportunities to try to renegotiate that clause, whether it's amending the existing agreement or entering into a new agreement, at some stage finding a premise to do that and seek to amend the clause, either so you replace it with a clause which is symmetrical, or you amend the asymmetrical clause so that you have some confidence that it will be enforced because you're bringing in jurisdictions and governing laws which will recognise and enforce it. The Mauritius commercial bank case, which I referred to earlier in the commercial court in London, that was quite an interesting one, because in that case, it was essentially a banking instrument. Bank lent monies, Mauritian bank lent monies to a borrower, and there was a guarantee. The original agreement provided for exclusive jurisdiction of the Mauritian courts and Mauritian governing law, so it was a symmetrical clause. After the judgment had been handed down in the Rothschilds case, they actually amended and entered into an amendment and restatement agreement, and they changed it to an asymmetrical clause, which provided that the English courts would have exclusive jurisdiction, save that the bank would also, at its option, elect to sue in any other court of competent jurisdiction. But crucially, although they changed it to an asymmetrical clause, they also changed the governing law so that it was English law which recognises asymmetrical dispute resolution clauses. What happened next was the Mauritian borrower and the guarantor defaulted. It went down to the commercial court, and the Mauritians, the defendants tried to argue that the amendment to the agreement and the new agreement to change it to English law was ineffective, and that Mauritian law still applied. And they argued Mauritian law is based on French law. Under French law, asymmetric dispute resolution clauses are unenforceable. Therefore, we shouldn't have to pay up. I think the commercial court gave that quite short shrift. It found that the change in the governing law was effective. It found that these asymmetrical clauses are enforceable English law, and the claimant obtained judgment. But I think it's useful because it brings into focus the fact that the practical position is a good example that parties will seek to use, for example, the position of French law to try to get out of asymmetric dispute resolution clauses and try to claw back tactical advantages. So it's a very real problem. It is an issue which will be seized upon by parties if it's in their commercial interest to do so. So, as I said earlier, if you've already got that type of clause, have a look. For example, is there a nexus with France, either because you need to enforce in France or because it's French governing law? And equally, if the Russian jurisdiction is relevant, do you need to enforce in Russia, etc. I've put on one of the slides, just beware oversimplistic solutions. It's often suggested, well, if you've got an asymmetric dispute resolution clause, make it governed by English law, because we know English law recognises them and enforces them, therefore we shouldn't have any issues. It's not quite that straightforward, because if, for example, you have an English governing law and an asymmetrical clause, but you want to enforce, for example, an arbitration award in Russia, whilst you could argue to the Russian courts, well, the arbitral tribunal had jurisdiction because the jurisdiction clause which gave the arbitral tribunal jurisdiction was asymmetric, it was given by English law, and that's fine. There's a risk, for example, that the Russian courts will turn around and say, well, that's fine, but what you're trying to do is enforce an arbitration award in Russia. It is a mandatory rule or a Russian law or a Russian public policy not to give effect to and enforce asymmetric dispute resolution clauses, and we find that the arbitral tribunal didn't have jurisdiction. So beware what might be an overly simplistic solution. And the final point really, which applies generally whenever you're drafting jurisdiction clauses, to get tactical advantages, get local law, and think about whether you need to get local law advice. Thank you very much.
Thank you, John. Definitely practical advice that we get asked from a lot of clients, what can we put in our jurisdiction clauses and how does it work? Well, thank you to all 5 speakers. I'm going to open the floor to questions. We're actually doing really well for timing today, so we have time for a few.
And I think we speculated the reason why it went all the way was that she actually had, she'd agreed a CFA with her solicitors. She had ATE insurance as well to protect against adverse costs, and she also had third-party litigation funding. So from her perspective, even though it wasn't looking great, I think she just rolled the dice to see whether she might get anything or not. Interestingly, now that she's been found to be dishonest, I suspect she will have massive coverage issues with all the insurance and everything else she had agreed. But no, she lived in this country. She's got assets that she paid out without any question.
And absolutely. I mean, I left the Telegraph in February, and I think for the last year of the period I was there, the oversight by the legal team increased enormously. The sort of appetite for more risky stories decreased, and it wasn't just the Leveson Inquiry. There were various other things that happened. The name escapes me now, but the very high-profile case of a lecturer in Bristol who was accused of murder, who escapes me now. All those extraordinary photos of him on the front pages of the red tops. There were issues there around subjudice, contempt of court, and these were taken very, very seriously across the board. I mean, there is without a shadow of a doubt that the Leveson Inquiry, you can call it a chilling effect, but it's changed the landscape within all the newspapers. No two ways about it. What that does do is it gives an awful lot of power to the other party, if you like. When the journalist is calling up, they perhaps don't have that same sense of arrogance or sense of entitlement or sense of power, however you want to call it. That shift of power has moved away from the media and towards the subjects that they're writing about.
Yeah, it's really I've always found in negotiations, if you're quite open and candid about why you're concerned to have a greater choice and what the commercial issues are for you, often you find that can be quite disarming for the other side. So if you explain, well, look, you're the borrower, I'm lending you a very large sum of money, these are the potential issues for me, I want to be able to enforce, and you've got assets there, I want the option to be able to properly secure the loan that I'm giving to you. I want an arbitration option because your assets are in this location and you don't recognise English court, that jurisdiction doesn't recognise English court judgments. It's very difficult for the borrower to come back and say, well, yes, I know that the court doesn't recognise English court judgments, but I still want exclusive English jurisdiction. And you often find at that stage parties are quite reasonable. And there's a degree. They tend to be more friendly commercial negotiations. As soon as a dispute resolution, as soon as a dispute's arisen, then the default position is they will agree nothing and assume that any proposal is intended to really get an advantage over them.
I'd like to thank them all for really an interesting, exciting breadth of talks, from press to piercing the veil, from self-reporting to sanctions, and even a bit of symmetry in there. A special thank you to Jonathan Russell coming from Alico to give his unique insight into the press and how that affects your legal disputes. So please, can you join with me just to thank them?